Hi, this is Suzanne Bouchard, instructor for American Institute for Paralegal Studies. In tort law class, we've been talking about the intentional torts, and in this lecture, I want to address an interesting subcategory of intentional tort, and that is invasion of privacy. The torts of invasion of privacy can cover a variety of situations, and the elements for these torts differ by jurisdiction. Generally speaking, though, the term invasion of privacy is really sort of a catch-all that usually covers four distinct torts: disclosure, intrusion, appropriation, and false light. Each of the invasion of privacy torts involve the intentional intrusion into somebody's private activities in such a manner as to embarrass, humiliate, or outrage a person of ordinary sensibilities, that is, the reasonable person. Disclosure is the intentional publication of embarrassing private affairs. The public disclosure of private facts is an actionable invasion of privacy, meaning you can sue somebody for it, if it would be highly offensive to the ordinary person to have those facts publicized, and if the facts are not legitimately matters of public concern. Disclosure tort amounts to unreasonable publicity about the plaintiff, but it must also involve facts that are not already part of the public record. So, for example, publicizing somebody's past criminal record would not really fall under the tort of disclosure because a person's criminal record is usually part of the public record. On the other hand, it's not a defense to the tort of disclosure that the facts are true so long as the other criteria are met. Intrusion is a form of invasion of privacy that involves the intentional and unauthorized intrusion, physical or otherwise, into somebody's private activities or solitude. In order to be actionable, the intrusion must be of a type that would be highly offensive to the ordinary reasonable person. Some examples of intrusion may include such things as eavesdropping, reading somebody's email, wiretapping their telephone, searching through their private possessions, that sort of thing. Appropriation is also considered a form of invasion of privacy. Appropriation consists of the unauthorized use of someone's name, personality, or photograph for the defendant's own benefit. In other words, this tort consists of appropriating some element of the plaintiff's personality for commercial use without the plaintiff's permission. An example of this might be using a famous baseball player's photograph on an advertisement for sporting goods. False light invasion of privacy involves publicizing something about the plaintiff that places the plaintiff in a false and objectionable position in the public eye. The law does not require that the publicized information be private, but it does require that it be false. This tort's really very similar to defamation in that the false publicity exposes the plaintiff to ridicule, hatred, or contempt. False light invasion of privacy may involve attributing to the plaintiff certain characteristics, conduct, or beliefs that are not true. Now, not all jurisdictions recognize all of these invasion of privacy torts. For example, a growing number of states are rejecting the common law tort of false light because it's too duplicative of the tort of defamation. Those that do recognize these torts may have different approaches to each tort. So a paralegal working in a personal injury law practice really should be familiar with which types of invasion of privacy torts are recognized in his or her state. If you're not currently a student at AIPS, and if you're interested in learning more about careers in the law, please visit our website at aips.com.